Thanks very much, Aidan. Firstly, I'd like to thank Eames Solicitors and Stubbs Gazette for asking me to give this presentation on the key developments and challenges in the Personal Insolvency Act. Just a little bit about me. First of all, I absolutely hate that photograph. I've lost a little bit of weight since then, and I wear glasses now. I'm, as Aidan said, a barrister. I was a criminal lawyer, and I suppose my biggest claim to fame was, as a wee little devil, I helped prosecute those two lovely ladies, the Scissor Sisters. So hopefully after today's session I still have my head in place. I left the Law Library and I joined Compliance Ireland in October of 2011. Compliance Ireland was set up, it was co-founded by our director Kevin O'Doherty with Mr. Peter Oakes, the present head of enforcement in the central bank. We are seeing a huge change when it comes to financial regulation, and specifically around personal insolvency. In the last 3 weeks, I've had about 4 or 5 new clients come to discuss about getting authorisation under the payment services regulations in Ireland due to the fact that a specific aspect personal insolvency practitioner might be needed to be regulated by the central bank at present under the payment services regulation. So with this, I've had to do a bit of research which tied nicely into Aidan's phone call from me. So looking back in the past, it has often been quoted in both national and international media and commentators that bankruptcy in Ireland was both Dickensian and antiquated. I've done a bit of research, and I think actually Charles Dickens became bankrupt himself. The bankruptcy laws have been reformed somewhat through the Personal Insolvency Act. And I'll be going through the different non-judicial processes and bankruptcy and the other parts of the regulation. Just to give you some sort of timeline, on the 24th of January 2012, the general scheme of the bill was published by the government for consultation. On the 26th of June 2012, the bill was published and presented for the first stage before Dáil Éireann. And then just coming up to Christmas, the 22nd of December, the bill passed through all stages of the Dáil Éireann and was enacted on the 26th of December. The only part that has commenced at present is Part 6. That is the appointment of the criminal court, circuit court judges. This is the first page of the Act. It's broken down into 6 parts. With every single bit of legislation, the way I get through it is I put a cold towel around my head and I work from the beginning and work the entire way through. But just Part 1 is the preliminary stages. Part 2 is the insolvency service, the establishment of the insolvency service, and I'll be speaking about their role going on further into the session. Part 3 are the insolvency arrangements, the meat of the Act. There's 3 non-judicial processes, and I'll be discussing those. Part 4 is the amending of the 1988 Bankruptcy Act. We had a slight amendment in 2011, but this is further amendments to the Bankruptcy Act, with the main change being the automatic discharge going from 12 years down to 3 years. Part 5 is the regulation of the personal insolvency practitioner. At present, we are still awaiting guidance on the actual regulation. Who will be the regulator? What are the minimum accreditation standards? And finally, Part 6 is the appointment of specialist judges of the circuit court. So the snapshot of the Act. As I said, Part 3 is these non-judicial processes. We have 3. Debt relief notices. This allows the write-off of qualified unsecured debt up to €20,000, subject to a 3-year supervision period. The next process is the debt settlement arrangement. This allows agreed settlement of unsecured debt, so unlimited unsecured debt. And then personal insolvency arrangement. This is the agreed settlement of secured debt up to 3 million. Now that can be increased with the approval of the secured creditors, and also unsecured debt. We're also looking at the reform of the Bankruptcy Act, introduction of the automatic discharge from bankruptcy after 3 years, down from 12, and as I said, the establishment of the Insolvency Service and the regulation of the personal insolvency practitioners. So if we look at the first one, the debt relief notice, the purpose behind this is a cost-efficient way of discharging unsecured debt up to €20,000. It can be written off by paying half the debt or following a 3-year supervision process. Now, there's certain qualifying criteria. You must have qualifying debts unsecured of €20,000 or less. Now, there are exempted debts such as criminal court fines, family maintenance, the service charges or taxes. You must have net disposable income of €60 per month or less a month. This is not including reasonable living expenses. You must have assets or savings of €400 or less. Now, there are exemptions in the Act for reasonable household appliances, reasonable tools, and motor vehicles of less than €1,200. And finally, you must be insolvent with no realistic prospect of being able to pay your debts within 3 years of the application date. Now, that has come down from 5 years from the original committees. So the way it happens is an authorised intermediary will make an application to the Insolvency Service on your behalf. They will then look at further fact-finding or fact-gathering. They'll discuss it with the Department of Social Protection and maybe the Revenue Commissioners. If they are satisfied that you're qualified, they will then publish the results to the authorised intermediary, which could be the likes of MABs and your creditors, and they will register the debt resolution debt relief notice. The second agreement, it applies to debtors who owe more than €20,000 in unsecured debt. And if the agreement is adhered to for 5 years, the balance of debts will be discharged. Now, the debt settlement agreement can be extended from 5 to 6 years. And I've gone through how the different stages. Firstly, the debtor will appoint a personal insolvency practitioner. They will need to, as Aidan said, make a full financial disclosure and also a sworn statement that they, of their financial assets, liabilities, and the fact that they're insolvent. If the personal insolvency practitioner is satisfied that the debtor qualifies, they will then make an application to the Insolvency Service for a protective certificate. And this is, I'll be discussing at the end about certain issues that could come out. If the Insolvency Service agrees that the debtor qualifies and they should be given a protective certificate, they will then make an application to the Circuit Court. The Circuit Court will then decide whether a protective certificate should be given. And then, if it is satisfied, it must grant their certificate. What the protective certificate will do is to give breathing space for 70 days to allow the personal insolvency practitioner to come up and develop a debt settlement agreement for the creditors. This protective certificate can be extended by court for a further 40 days. What the personal insolvency practitioner will then do is they'll convene a meeting with all the creditors, and they will vote. And as Aidan said, if 65% of the present creditors, 65% in value, vote in favour of the debt settlement agreement, it is then presented to the courts, and if there's no proper objections and the eligibility criteria is met, then they will grant it. When the debt settlement agreement is in effect, no unsecured creditor may take action against the debtor. However, it is not I look at it and then forget about it for 5 or 6 years. It has to be reviewed at least annually by the personal insolvency practitioner to make sure that there has been no circumstantial changes with the debtor. If there has been a change in circumstances, the debt settlement agreement can be changed. The next area, or the third non-judicial process, is the personal insolvency arrangement. This covers secured debt up to 3 million and unsecured debt of at least 20,000. As I said, it can be higher amount if the creditors agree to it. What the personal insolvency agreement is mainly for is debtors with mortgage debts and arrears. So it is quite a similar process to the DSA. You appoint, or the debtor appoints, a personal insolvency practitioner. They must demonstrate that a DSA is not suitable. But also, what you also must do is that you must demonstrate that it is highly unlikely that the debtor will be solvent or be able to pay back their debts in the next 5 years. And also, the debtor must have fully cooperated with the bank in the previous 6 months and signed a statutory, as I said, a sworn statement, signed statutory declaration of their financial position. Similar to the DSA, they will apply to the insolvency agency for the protection certificate. This is to allow the PIP to gather information. And again, proposal will be drawn up to manage the debts over a 6 to 7 year period. As Aidan said, for approval, you need to get 65% of the total creditors in value must be in agreement, 50% of unsecured and 50% of secured. It is then registered with the insolvency agency, and if the creditors or certain creditors feel that their rights have been prejudiced, they can make an application to the circuit court to allow those rights to be heard. As I said, where a PIA or personal insolvency agreement becomes operative, it'll bind the directors and creditors and must be reviewed, same as the DSA, at least annually. If there is a change in the circumstances, a new personal insolvency agreement or amendments need to be made. However, if new assets come into the debtor's possession, only 50% of those assets of those new assets can be used made available to the creditors. So that's an interesting one. So the next area that really has been amended is bankruptcy law. And it's been updated in the following ways. So the discharge period has come down from 12 to 3 years. As Alan will be talking about, I believe in the UK it's 1 year. So there has been certain commentators trying to make the point that they should, the Act should have had cognizance to the fact that bankruptcy tourism could still take place, because although it's 3 years in Ireland, it is still 1 year in the UK. However, the 3-year discharge period can be extended up to 8 years if an application is made that the person is not cooperating with the debtor, or they've hidden or failed to disclose assets. So the 3 years can be extended. The court also has the discretion to order the debtor to make further payments into the bankruptcy for a period of 5 years after the discharge. Probably one of the biggest changes is in the past, you had to, a creditor could make an application for a person to become bankrupt if the debtor owed circa, I think it was €1,900 or €1,300 non-partner debts. So to make an application or petition for an individual's bankruptcy, it has to be over €20,000. Also, the review period will increase to 3 years in some cases. So a look back on your transactions or your conveyancing or your sale of certain assets, so potential fraudulent reference transactions can be overturned of a 3-year clawback period. The offences stay the same. I always use the offences in any of my presentations. So on a summary conviction, a fine of €634 or up to 12 months in prison or both, and on indictment a fine of not exceeding €1,269.74 or up to 5 years prison or both. I was doing a bit of research. Only in the last few weeks there was a director of a UK entity sentenced to jail for fraudulent conveyancing and not disclosing the full financial or a sale of an apartment that they had. So I've discussed the non-judicial processes. The next area, new area when it comes to personal insolvency law, is the role of the Insolvency Service. So this is an independent body to participate in the delivery, monitoring and execution of insolvency arrangements. So, as I said, the principal functions are monitoring arrangements relating to personal insolvency, considering applications for debt relief notices. The authorised intermediary will make it specifically to the Insolvency Service and they will make the decision. They'll also be processing applications for protective certificates for debt settlement agreements and personal insolvency agreements. So it's an extra layer of protection. So it goes from the PIP to the Insolvency Service. They'll make a decision. They will then pass it on to the Circuit Court for the Circuit Court to make their decision. The Insolvency Service will also maintain the registers of the DRNs, the DSAs and the PIAs. And a very, very important role of the Insolvency Service is they'll be developing policies and updating the public. I think this is a very, very unsettled area of law. We're going to get an awful lot more information in the near future. As I said, only Part 6 has been commenced. We still have to get guidelines about what accreditation the personal insolvency practitioners is. So I think it's going to be a very, very important role of the Insolvency Service to update members of the public. So what is a personal insolvency practitioner? They are, one commentator called it, the honest broker between debtors and creditors. It is not a one-time thing. They will have to review the processes and the arrangements at least on an annual basis, or when there's new material changes to the actual circumstances of the debtors. They'll call meetings with the creditors to approve proposals. So they'll design the procedures and then they will convene the meetings. They'll also report on the regular basis to the Insolvency Service, and also they'll manage and supervise the debtors throughout the term. So I see a couple of issues with this. Firstly, majority creditors. There's no requirement on creditors to approve any of the proposals. So this could mean that the majority creditor which in a lot of cases could be a bank could veto the arrangement, or could in fact bully a minority creditor. Now, there is a procedure to make an application to the circuit court if the creditor feels that their rights have been prejudiced. Bankruptcy tourism. As I said, 3 years for automatic discharge. It's still 1 year in the UK. So if a person was mindful, it could still have a bankruptcy tourism. Personal insolvency practitioners, we still don't have the guidance on the accreditation of the personal insolvency practitioners. We don't know if being an accountant or a solicitor will suffice. It is still a big area of when do they get paid, how do they get paid, how much do they get paid. Also other issues, one that I don't have here is, this is quite a large act. There's 199 sections and 2 schedules. It's about that thick, double-sided. It is quite legalistic. So what is meant to help people in their personal insolvency areas, they might need to get legal advice to be able to do so. Also, there's an extra layer of bureaucracy. There's the personal insolvency practitioner to the insolvency service to the circuit court. So some commentators have stated that it's an extra layer of bureaucracy, too much. Finally, it is difficult to ascertain that a person will not be in a position to realistically discharge their debts. This is for debt relief notices for 3 years and personal insolvency agreements for 5 years. So that could be, we need more guidance on that. And finally, we probably need more guidance on reasonable living expenses. So to sum up, it is a big move forward for personal insolvency. Compared to the antiquated laws in the past, we now have non-judicial processes. They have their pros and cons. There's still issues we need further guidance on. And we just have to wait and see how the uptake of it is. I think, Aidan, you were talking about in the past you could count on 2 hands the number of bankruptcies, and they're expecting 3,000 and 15,000 for the PIAs and the DSAs. So it is an area that we'll just have to keep an eye on. Do you want to leave the questions until?
Perhaps there's time for 1 or 2 questions. Or maybe we can save them up to later on. Thank you very much.
Thanks very much.